A Mariva injunction, first developed in Mariva Company Novera SA and International Bulk Carriers SA 1975, is one of the most important legal tools to stop defendants from concealing or dissipating assets that might be used to satisfy a judgment. This has become a necessary injunction to protect claimants' rights with the development of an international banking system where the transfer of assets can become virtually instantaneous. The injunction prevents defendants from defeating legal claims through the disposal of assets. The injunction is usually granted without notice, but its provisions are supported by Section 37 of the Supreme Court Act 1981 and Section 25 of the Civil Jurisdiction and Judgment Act 1982. It prevents the defendant from transferring or parting with assets, whether situated within or outside the court's jurisdiction. These are granted by the courts when there is a real possibility of dissipation of assets and the defendant is forced to disclose his asset. Third parties such as banks may be joined in this regard to furnish information about the financial standing. In this way, the freezing order protects the integrity of the courts, the enforceability of judgment, and prevent abuses of process, making them dispensable in today's fast-moving, interdependent financial world.
To prevail in a Mariva injunction, the applicant must satisfy three conditions, as highlighted in the case of Credit Vanishing Sdn Bhd against Wongkoi. First, a good arguable case. The applicant must demonstrate a good arguable case. This means that the plaintiff's claim must be more than minimally capable of serious discussion. It does not necessarily suggest that the judge believes it has a superior chance of success, but it indicates that the plaintiff can present a coherent and credible narrative supported by legal principles that could potentially yield a claim with plausible remedy. Second, within the jurisdiction, the applicant must provide proof that the defendant possesses assets within the jurisdiction. The primary purpose of the Mariva injunction is to assess whether the defendant's assets should be freezed to safeguard the applicant's interest in an ongoing legal proceeding. The applicant must specify the distinct assets such as bank account, real estate holding, or investment, and present evidence confirming the defendant's ownership or control over these assets. Lastly, real risk of the asset being dissipated. The applicant must demonstrate a real risk that the defendant may dissipate or transfer their asset before the judgment. This risk must be supported by the solid evidence, as failing to secure the Mariva injunction could hinder applicant's ability to recover funds or property owed the following judgment. The court may consider various factors, including the integrity and behavior of the defendant. The integrity and behavior of the defendant are of significant importance in this matter, as seen as in the case like Jasa Kramat Sdn Bhd versus against Monetas Malaysia Sdn Bhd. It is essential for this court to revisit the circumstances surrounding this case. In this review, the court is reminded of the defendant's action in utilizing the plaintiff fund inappropriately. The withdrawal made by the defendant, which lack property documentation, indicate that their integrity, as evidence thus far, is indeed questionable. In conclusion, obtaining a Mariva injunction requires the applicant to establish a good arguable case, prove the existence of asset within the jurisdiction, and demonstrate a real risk of asset dissipation. This condition was to ensure that the plaintiff's interests are protected while maintaining fairness in the legal process.
My name is Risha Selvandia, and I will be explaining about the differences of freezing orders between domestic and extraterritorial Mariva injunction. The key distinction between extraterritorial and domestic Mariva injunction lies in the range of assets affected by court order. A domestic Mariva injunction in Malaysia prevents a defendant from handling or transferring assets within the jurisdiction to avoid legal obligation. To obtain it, the plaintiff must show a good arguable case, prove the defendant has assets within the jurisdiction, and demonstrate a risk of dissipation. The injunction lasts up to 21 days unless renewed or set aside, and specific timelines apply for filing suits or serving the order. In the case of IB Builders and Denberhard versus Tentuan, Theo, and Chiu, and four others, the plaintiff sought a Mariva injunction to freeze a certain amount alleging improper disbursement by the stakeholder. Defendant 1 argued that Defendant 3 judgment sum of 65 million from another case constituted assets within the jurisdiction. The High Court denied the injunction, ruling the judgment sum, even it's finalized, does not qualify as assets within jurisdiction. Unless the funds have been paid to the defendant, this clarified the judgment debts alone cannot be used to support Mariva injunction without the proof of payment. An extraterritorial or worldwide Mariva injunction prevents the defendant from handling assets globally. In England, such an order may be granted under special circumstances, provided it can be enforced effectively and aligns with the international law. To obtain one, the applicant must prove a legal and equitable right, the court's jurisdiction, a strong case for a specific sum, the existence of the respondent's asset not necessarily within the jurisdiction, a real risk of asset dissipation, and local assets are insufficient to cover the claim. The applicant must also give an undertaking as to damages. While the injunction can restrict the defendant globally, enforcement against third parties outside the jurisdiction requires registration or a similar injunction in a foreign court. In the case of Kitmas Capital Sdn Bhd versus NRB Holdings, the Malaysian Court of Appeal upheld a worldwide injunction to freeze the appellant's global assets. This based on the evidence that was the appellant might dissipate assets to frustrate a potential judgment.
Moving on to the jurisdictional basis for issuing the freezing orders. First, Order 29, Rule 1 of the Rules of Court 2012 (ROC), the applicant must fulfill before a MURSHAMSHUL injunction can be granted. The application is made through a notice of application accompanied by an affidavit. In urgent cases, the application may be made ex parte, meaning that one party can request the court for an order without giving the other party the usual notice or the chance to oppose the request. In the case of Wacom Merchant Banks and Lim Lian Heng and the others, the defendant owed a debt to the plaintiff under a judgment obtained in Singapore, which was later registered in Malaysia. To secure the defendant's property in Malaysia, the plaintiff applied for an ex parte MURSHAMSHUL injunction. The court then granted the ex parte order, but as it was time limited. Second, Arbitration Act 2005. A party can apply to the High Court for interim measures to prevent asset dissipation that could render an arbitral award ineffectual. This application can be made before or during arbitration proceeding. In the case of Ikatan Inovasi Sdn Bhd and KACC Construction Sdn Bhd, the court clarified that while preservation orders for property may not apply to disputes over liquidated sums, other provisions allow the High Court to ensure an arbitral proceeding is not rendered worthless due to asset dissipation. Third, Sharia law. The MURSHAMSHUL injunction has also been applied whereby it is more related towards family matter. The Sharia court had made an attempt to use the MURSHAMSHUL injunction within its jurisdiction, especially in the case of settlement of divorce. The use of MURSHAMSHUL injunction is to prevent the dissipation of jointly acquired property during divorce proceedings. The MURSHAMSHUL injunctions are unfamiliar to Sharia court judges. Thus, any order issued by the Sharia court is only effective within a specific state's broad maxim. The first maxim is he who seeks equity must come with clean hands. The maxims prevent the defendant from removing or dissipating their assets outside the court jurisdiction. Second, equity acts in personam, which allows the court to expand the jurisdiction to issue an injunction located outside its geographical reach. Third, equity will not suffer a wrong to be without a remedy. It assures when a party suffers harm or loss, the court will provide an appropriate remedy to the party, even if no specific legal remedy exists. And last, equity follows the law, which means equity can provide remedies in situations where the strict application of the law may be inadequate. It does not override or contradict the law.
Okay, so we are moving on to the limitation and challenges of MURSHAMSHUL injunctions. Okay, the first one I will discuss about limitations. The first one, MURSHAMSHUL injunctions face inherent limitations, especially in cross-border situations. That means, enforcing MURSHAMSHUL injunctions internationally requires navigating different jurisdiction laws, creating challenges in asset identification and compliance. The second one, the injunction's effectiveness depends on third-party compliance. Third parties like bank must act on the injunctions to ensure assets are frozen, placing the burden of enforcement on entities not directly involved in the dispute. Furthermore, third parties are liable only if they intentionally breach the injunctions. That means banks and their employee may face legal consequences for non-compliance, emphasizing the need for clear communication and adherence to court orders. And the last one, generalized orders apply when specific assets or accounts are unknown. This can lead to increased administrative burden on third parties like banks to locate and freeze relevant accounts, which may delay enforcement. Okay, next I will discuss about challenges of MURSHAMSHUL injunctions. The first one, judicial oversight and international cooperation are critical for effectiveness. Which means without proper coordination between jurisdictions, enforcing MURSHAMSHUL injunctions across borders become impractical and limiting their reach. And the second one, timely and formal communication with third parties is essential. Any delays in notifying third parties may allow defendants to dispose of assets and undermining the injunction's purpose. Moreover, bank must act swiftly upon notification to freeze assets. That means compliance depends on clear instructions, and delays or negligence could result in asset dissipation and legal consequences. And the last one, malevolent injunctions can disrupt third parties' business activities. For example, port authorities may lose revenue, illustrating the broadest economic impact of such orders.
For the conclusion, as stated above, a MURSHAMSHUL injunction or freezing order prevent defendant from transferring or concealing assets that may satisfy a plaintiff damages, ensuring the legal system is upheld and claimants are compensated. Since it originally in the MURSHAMSHUL case, it has become essential, especially with the ease of cross-border asset transfers via advanced financial system. There are 3 requirements an applicant must satisfy to have a MURSHAMSHUL injunction issued. First is the applicant must show that the defendant has asset in this jurisdiction. Second, there has a good causes. Third, a real risk of dissipation of asset. This ensures that the applied order is fair and only when necessary. The scope now extends globally, allowing courts to freeze asset cross jurisdiction, while securing such order requires showing that assets are at risk internationally. Enforcing them depends on cooperation with foreign courts. Into this interconnected words, MURSHAMSHUL injunction uphold legal integrity, protect claimants' rights, and combat financial strategies that evade accountability, emphasizing the need for strong enforcement and global collaboration.